Thank you everyone for joining us today for a webinar that will provide an overview of the new Federal Maritime Commission's Ocean Transportation Intermediary Rules. Today's webinar is being hosted jointly by Venable LLP and FreightGate. My name is Ashley Craig. I'm a partner with Venable in Washington, and I also co-chair our firm's International Trade and Logistics Group. I'm joined by my colleague Elizabeth Lowe, who's also a member of our group. Alongside us on the West Coast is Martin Hubert of FreightGate, principal and founder of the company, who will provide his thoughts and comments towards the end of our webinar. I'd like to thank Martin for helping to contribute to the webinar and providing and helping to facilitate the support necessary for us to come here today. Our objective today is quite simple. We'd like to provide you, our audience, with insight and commentary on the FMC's new rules that ultimately translate into a practical understanding of how ultimately the rules may affect you. Our audience includes shippers and BCOs, carriers, and intermediaries. The new rules seem to have struck a note with all segments of the international maritime industry, and this is a very good thing. As we move through our presentation today, we will attempt to touch on how certain parts of the new rules may be of particular interest to a sector or two of the industry. We will keep in mind that we have before us all segments of the industry. We have also included some practical suggestions along the way for your consideration. Before we begin, a few practical notes. We will have a question and answer period towards the end of the presentation. Please keep that in mind as we go through our discussion today. The audience will be able to send questions to us via chat. We will do our best to get to your questions. If for some reason, likely due to time allotment, we're unable to answer all of the questions, please do feel free to follow up after the presentation by email. We'll do our best to get back to you in a timely fashion. Lastly, please know that this presentation should not be considered as legal advice on the issues discussed today. You should consult an attorney for specific legal analysis and advice if you have questions. In terms of logistics, regarding our presentation, Ms. Lowe and I will share in moving back and forth through the issues and a breakdown of the new rules section by section. We'll outline our practical suggestions for you along the way, and then we'll turn to Martin for his thoughts towards the end. Lastly, we'll move into a question and answer session. We have allotted about 60 minutes for the presentation, comments, and Q&A. Please go ahead and look at your watches and keep that in mind as we move through. We'll do our best on our side to expedite our thoughts and commentary if we get bogged down along the way. We do want to leave a good 10 or so minutes for everyone to ask questions if you have them. And on that note, let us begin our presentation and our look at the new FMC OTI rules. The overall theme of the FMC's approach to the new rules. Quote, the new OTI rules adapt to changing industry conditions, improve regulatory effectiveness, improve transparency, streamline processes, and reduce regulatory burdens. Now, the FMC was fairly clear here in terms of their approach to the new rules, and they did, in all sincerity, try to strike a balance among the themes that you see before you here. And I do think that as we go through this discussion today, you'll see the FMC did do a decent job of touching point on each of these. And having said that, we will now move into the background on the OTI rules. The rules, which were made publicly available back in November of 2015, represent the most sweeping set of changes to the OTI regulatory environment since passage of OSRA, which is the Ocean Shipping Reform Act, which modified the underlying statutory rules of the Shipping Act of 1984. OSRA, of course, as a piece of congressional consideration, required that the FMC move forward with implementation of day-to-day rules. That resulted in the 1999 adoption of a set of OTI rules. That was the last time that the FMC touched this environment in such a significant way. Even though in 2013 the FMC advised everyone by way of a notice of advanced rulemaking that they were going to be looking at the OTI rules and the regulatory environment In earnest, the FMC had already started to look at it at the beginning of the decade by meeting with stakeholders, having discussions. There was a general consensus that the time had come for the agency to revisit the OTI regulatory environment. So in 2013, everyone got an advanced look at what the FMC was considering. It was a fairly sweeping proposal. That triggered thoughts and comments from the industry and stakeholders, which the FMC then considered along the way, which led us to 2014, when the FMC published in the Federal Register a notice of proposed rulemaking. That initial set of proposed rules would have introduced rather wide-ranging regulatory changes to the OTI environment from a regulatory perspective, both for U.S.-based and non-U.S.-based OTIs. Many of those provisions in the proposed rule were eventually eliminated in the final rule, which we refer to here today as those published in November of last year. Perhaps the most significant change in the final rule is the renewal process that now attaches to everyone that holds an OTI license today, as well as those that are contemplating seeking a license and will obtain one from the FMC in the days and the years to come. This change actually has a catalyst in the FMC's relatively long-standing concern that some OTIs were not properly updating the FMC when it came to material changes to the organization as required by the FMC rules. So that provides a general sense of the background and the overview. We'll now turn to the license renewal requirement that's embedded in the new rules, and I will turn to my colleague Liz Lowe.
As Ashley noted, the license renewal requirements are perhaps the most significant change in the OTI rules. Essentially, the rule requires that all licenses must be renewed within 3 years, at a 3-year time frame. For new OTI licenses, that's licenses that are issued after December 9th, 2015, those licenses will only be effective for 3 years. The licenses will state on the face of the license their expiration date. For existing OTI licenses, those will also expire within 3 years, but within 3 years of December 9th, 2016, which is the date that the license renewal requirement becomes effective. Unlike most of the other changes, this one change does have a later effective date. During this year, slightly less than a year at this point, the FMC will publish on their website a schedule with regard to the existing licenses as to when those licenses will need to be renewed. We anticipate that it will likely be grouped by license numbers. So that is something that the OTIs on the line should be aware of and be looking out for. It's worth checking the FMC's site occasionally, although we do anticipate that the FMC will provide notice when that schedule goes up so that you can keep tabs on when your license will need to be renewed. All renewed licenses will include an expiration date going forward, so you will know when your license renewal must occur. Licenses should be renewed no later than 60 days prior to the expiration date. The FMC does plan to provide email notification of impending renewal dates, but that being said, we recommend that you monitor those dates yourselves as well to make sure that you don't miss the renewal date. The Commission has made it quite clear that they intend this to be a straightforward and simple process. They don't intend this to be an additional regulatory burden. The renewal process will be completed on the FMC's online portal. It will likely require confirmation of the existing OTI information, or if you have changes in your OTI information, update to the same. Again, the FMC has essentially a year from December 9th, 2015 to put in place the renewal process, and we anticipate that there will be notices provided, press releases, etc., that give us updates as to how the renewal process will actually proceed after December 9th, 2016. There will not be a license renewal fee, again, in an effort to reduce the burden of this new requirement. In the event that an OTI were to fail to renew their license is not terminated, or their effectiveness is not terminated immediately. Again, the Commission would like to work with the industry. This is not intended as a punishment. We anticipate that they will likely reach out to the OTI, notify them that the renewal date has passed, encourage them to go through the renewal process. In the unlikely event that an OTI does not respond to the FMC's reminders, the FMC does have the option to bring an enforcement proceeding that would either suspend or revoke the license. This process, however, is subject to the notice and hearing requirements. We will address those slightly later in the presentation.
Thanks, Liz. The rules that we've touched upon briefly are rather comprehensive. We've alluded to the fact that this represents the most significant adoption of changes to the OTI rules in over a decade. And we're now going to turn to the additional rules outside of the license renewal requirement that Liz walked us through, which is, as we've made very clear, frankly, a very new requirement indeed for everyone. So, turning to the additional rules which are effective, the FMC took this opportunity to conduct some streamlining, some house cleaning, if you will, of definitions in the governing OTI rules that have been there for quite some time. This is a combination of the fact that the rules have not been refreshed in over a decade, and on top of that, we're dealing with an industry which has been regulated in one way, shape, or form since 1916, in terms of OTIs in earnest since the early to mid-1960s. The industry has changed, the industry has evolved, it has adopted new procedures, it has also adapted to a new environment which includes additional security elements after post 9/11, as well as the introduction of technological advances to help with more efficient movement of international commerce. Thus, the FMC took this opportunity to refresh its own set of rules and definitions. Starting with that, the FMC decided it was time to update the definitions of freight forwarding and NVOCC services. In particular, for example, I should say, the reference to electronic export filings, or EEI, which is something that is not directly under the FMC's jurisdiction. I think everyone online understands that that is a Commerce Department, Census Bureau area of expertise. We're talking about here, to date some of those online, including myself, the elimination of a reference to a shipper's export deck, which was a paper filing, and the adoption of the electronic form, which now has superseded the SED. The FMC also adopted or tried to current industry practices along the way by refreshing how they define forwarding and NVO services. In addition, there was the new definition of registered NVOCC, defined as a non-US NVO that does not become licensed as an NVO, but registers with the agency, publishes a tariff, and posts a bond. This has been the requirement since OSRA was implemented by way of the regulatory requirements that the FMC back in 1999 pushed forward. The FMC today has decided to solidify that, and they did so by this definition. The FMC also took the opportunity to remove some static, some stale terms that, upon further reflection, the industry was just no longer using in any significant way. For example, ocean freight broker, which was an entity that was acting on behalf of a common carrier, be it NVO or VO, to essentially ferret out opportunities and then direct that to the actual common carrier. In essence, this is an agent acting on behalf of a disclosed common carrier principal, and the FMC thought that it was frankly more practical to just let an agent act as an agent, and we'll talk about that a little later in our presentation today. The definition of brokerage in terms of ocean freight forwarding brokerage was eliminated. FMC, upon reflection, said it's just not being utilized today. And then small shipment was removed from the cadre of FMC definitions here. Our practical suggestion point here, this is a good time for you to take a look at agreements that you may have in place and determine if you have used any of the definitions that have been eliminated. In all likelihood, it may be brokerage, it might be an ocean freight broker. For those of you that have ocean freight broker agreements with entities out there acting on your behalf, now's the time to go ahead and remove that, refresh it, make certain that you're referring to them as an agent. We can't obviously speak at this point to specific agreements that may be in place from the audience, but from our own experience, both Liz and I have drafted more than our fair share of ocean freight broker agreements where we have cited to the actual definition in the CFR, and the FMC's actions over the last couple months, of course, eliminate that. So there is a practical need for folks to go ahead and update and amend agreements because, frankly, you would be referencing a citation that no longer exists. So, moving on to branch offices.
Another significant change, actually two significant changes that were made, have to do with branch offices, OTI branch offices. The first is that separately incorporated branch offices no longer need to obtain and maintain individual licenses. Practically speaking, we would expect that during the renewal process, the license renewal process, the FMC will likely coordinate with those entities, those OTIs, that do have separately incorporated branch offices to phase out the licenses for those separately incorporated branches and bring them under the license of the, if you will, the parent OTI. But again, that's something that we anticipate to see in the next year or so. The second change here is that OTIs no longer need to maintain additional financial responsibility. So on top of their required bonds, they used to have to maintain $10,000 additional per branch, per bond, for each unincorporated branch office. That requirement has been removed completely. Now there are pros and cons to this requirement depending on who you are. So for OTIs, you're going to see an immediate cost savings here. Your bonds can be reduced to $50,000 for freight forwarders, $75,000 for NBOs. As noted earlier, this was effective as of December 9th of last year. So we'd recommend that you coordinate with your surety if you haven't already to adjust those bond amounts, and you should see a reduction in your bond premium that you're paying. Now, on the other hand, for BCOs, beneficial cargo owners, NBOCCs that are acting as shippers, it's important to note that there is now a lower bond amount. So you should give thought to whether additional coverage is needed in the event that there's some sort of transportation-related claim, instead of having, for example, $150,000, $175,000 bond that's out there to help address transportation-related claims. You're now looking at either $50,000 or $75,000. So it's a smaller pot, if you will. And that's a practical thing that should be kept in mind when you're engaging an NBO or a freight forwarder for their services.
Thanks, Liz. Moving along, the FMC also took the opportunity to solidify some longstanding policy, if you will, in the area of claim reporting. Now, you just heard from Liz that the bond amounts are being essentially adjusted, in effect lowered. The initial proposal from the FMC a few years ago was actually to up the bond amounts to provide additional coverage in specific instances where you had multiple claimants involved in a variety of cargo loss and damage issues, etc. At the end of the day, the FMC, upon further reflection, consultation with the industry, and receiving input from stakeholders, decided to lower the premium amounts, or I should say the bond amounts, which will translate into lower premium amounts to those online that hold those and have to secure the underwriting. Before you now is a simple slide that states that the sureties, those that are underwriting the actual financial instruments, the bonds for the NBO or the forwarders, must provide the FMC with notice of claims as well as claims paid against an OTI bond. I mentioned at the beginning of this slide that this was the, if you will, the attempt to solidify by the FMC a long-standing policy. So if there were any sureties online today, and I'm not certain if there are, I'm sure you would be saying, well, we've been doing this more or less for a while. That is correct. It has now been codified, it is embedded in the FMC rules, and it is now a requirement, pure and simple. So what you're going to find, of course, are sureties reporting to the FMC, even if it's a nascent claim. So if counsel is engaged to approach a surety and make a claim against the bond for ocean transportation-related charges, in addition to, say, the traditional cargo loss and damage claim, but it could be even failure to pay freight, for example, very typical, then the surety is going to have to collect those initial claims and advise the FMC. In the case where there's actually an amount paid against the bond by the surety, they will also, they being the surety, have to advise the FMC of the claimant's name, if there's actually a proceeding, a legal proceeding, the court, the case number, and of course the OTI name and the OTI license number. Now the FMC has permitted the sureties to aggregate this data submission and do so collectively, but to do it at least on a monthly basis. Now, most importantly, the claims that are provided to the FMC by the sureties will not be published by the FMC. Now, this is an area where we have a bit of conjecture. We're going to be, of course, deferring to the FMC as it goes through further refinement of the final rules in the days to come. But looking at the final rule and the commentary from the agency, it's not going to be readily available, meaning you're not going to be able to log on to the FMC website and download a list of surety claims as well as amounts paid out on a fairly user-friendly basis. Whether it's subject to a Freedom of Information Act or a FOIA request is up for debate and further consideration. But there were concerns raised during the rulemaking process that the publication of this type of data might actually be adverse to OTI operations, especially if we're talking about an initial claim, not the actual legal proceeding which led to the payout against the bond. As a result, the FMC struck a balance here. The data will be collected. It will be required to be submitted. However, it's not going to be readily available on the FMC website. So we're now going to turn to an area that is interesting and, of course, important to day-to-day operations for OTIs, NVOs in particular, but it also does touch base with ocean trade forwarding activities, and that is the use of agents. Some online may recall that over the past decade or so, the FMC has dealt with the issue of agents on more than a few occasions. And it had become a hot topic at some point. It had then stabilized. How agents were being used, employed domestically primarily by licensed OTIs was something that helped to form the catalyst for the agency to take a look at the OTI rules more than a few years ago. At the end of the day, however, what we see before us in the final rule from November of 2015 is, in sum, no real material change for licensed NVOCCs when they use agents. In sum, a licensed NVO in the U.S. or overseas, for that matter, is still authorized and able to use non-licensed entities as agents. Again, that's not a change from the way that the industry has been operating for a number of years, albeit some ebb and flow as this issue has come before the agency in the past decade or so. Further, the final rule touches upon a registered, that is a non-licensed NVOCC, in essence non-US based, underscoring that such an NVO must use a licensed OTI as an agent in the United States. This is a traditional receiving agent, if you will, acting upon delivery of an inbound shipment to the United States. This codifies the Commission's requirements contained in Form FMC 65, which is the process by which essentially non-US based foreign NVOCCs have to go through the registration protocol. Those of you that are online that work for or operate as a non-US based NVOCC and you're registered with the FMC will recall that over the last couple years, the FMC has approached you with the Form FMC 65 and has asked you to fill out and respond back to the agency in due course. You may recall that that form also asked you if you were using a U.S. agent, and you're not required to, but if you are, and practically speaking everyone does, then you were to identify what that agent is, and of course that agent had to be a licensed OTI. That was the FMC's first attempt to obtain from the foreign/non-U.S. NVOCCs confirmation that they were using licensed U.S.-based OTIs as agents here. They've now codified that in the rule, and it's fairly clear. No more gray area. It's there. It is a requirement, and it's something that has to be adhered to. In terms of practical suggestions on this point, we have a reminder, and that is quite simply that OTIs are fully responsible for the actions of employees and agents, and that's actually in the commentary that you'll find from the FMC in the final rule. This is nothing that anyone online should find to be earth-shattering. It frankly is a reflection of long-standing principal agency law here in the United States. When you employ an agent acting on your behalf, that agent, of course, can do good and at times do bad for you, and you as the principal need to be mindful that you may inherit exposure based off of the agent's activity, conduct, misconduct, or misbehavior. So as a reminder, just be aware that your agents are acting on your behalf, and that's good, and it potentially may be somewhat complicated from time to time.
The FMC also updated the provisions, regulations relating to verifying proof of NVOCC compliance. Now, they didn't make any substantial changes here, really just sort of clarifying, updating the language. As a reminder, which I'm sure everybody is well aware of, but no common carrier, so that's a VOCC or an NVOCC, may knowingly and willingly transport cargo for an NVOCC unless that carrier has determined that the NVO is properly licensed, registered, and in compliance with the FMC requirements. The new regulations clarify that the Commission posts a list on its website, which they have done for some time now. There is a searchable list on the website, a specific list devoted just to NVOCCs. That list includes NVOs that have met all applicable licensing, registration, tariff, and financial responsibility requirements. In order to comply with a common carrier's obligation to verify an NVO's compliance, that common carrier can simply look at this list. And as long as the NVO is on that list, then they have met their requirements, their obligations under the Shipping Act to verify compliance. Now, we do note that if the common carrier has actual knowledge that an NVO is not in compliance, then that's going to trump. You can't get out of a Shipping Act violation by saying, well, I knew they were not in compliance, but they were on the FMC's list. So the FMC does update the list periodically, but it's not updated on a daily basis. So, it is possible that there could be an NVO on there who is not fully up to date, hence why you need to still be aware of the individuals that you're working with. As far as practical suggestions, for VOCCs and NVOCCs when they're acting in the capacity as a carrier, be sure to check the OTI list. You can still feel free also to ask the NVOCC for proof of their tariff and financial responsibility. You don't have to. You can look at the list, but again, it doesn't hurt to do that. For BCOs, for beneficial cargo owners, shippers, NVOCCs, when you're acting as shippers, we would highly recommend consulting this list just as part of your due diligence before engaging a logistics provider. If these entities are on the list, then they should be in compliance. You can be sure that they have a bond in place to help cover any potential claims that you may have. If an NVO does not appear on this list, that should be a big red flag, and we would not recommend engaging their services. Another, what I'll call update to the rules is for the character requirements. These are for the OTI license eligibility. Now, these are not new requirements, as the FMC has said. These are issues, relevant information that the FMC has always considered, but they've now specified those points, which is helpful to the industry. So if an entity is going in to apply for an OTI license, you can now look at the regs and be aware of the specific type of information that the FMC might consider when determining whether an entity has the proper character to obtain an OTI license. Some of these include obviously violations of any shipping laws. That's a pretty clear one, but also violations of any statutes, laws relating to import, export, or transportation of merchandise in international trade. So, for example, violations of U.S. sanctions laws, U.S. export controls laws, violations of customs laws. All of those things can be considered by the FMC when determining whether to issue a license. Operating without a license or registration, any criminal violations, bankruptcies, failing to properly monitor the immigration status of employees and ensure that they are in compliance. Also, any denial, revocation, or suspension of either TWIC, the Transportation Work Identification Credential, or Customs Broker's license. That will all be considered by the FMC. So from a practical standpoint, if an OTI has any concerns with any of these areas, those concerns should be addressed, disclosed, remedial measures put in place prior to seeking the issuance or renewal of an OTI license application to avoid any unnecessary delays in the process.
I would just add, before we move on here to Liz's comments, what we're seeing by way of this particular provision is the FMC recognizing what many other federal agencies have been coming to terms with in the last, I'd say, decade or so. For example, export control compliance, potential embargo violations. The industry, meaning the 3PL, the forwarder NVO industry, has become, let's just say, an area of interest for other government regulators. And the FMC now is bringing into its fold the recognition that an export compliance concern that may be before the Commerce Department or the State Department or Treasury is something that FMC will take into consideration. Now, practically speaking, it's something that for the longest time the FMC could and at points in its history did factor into whether to issue a license or whether an existing licensee should continue to operate. But in the post 9/11 world in which we find ourselves today, there's greater cooperation and transparency amongst the different sister federal agencies that are involved in transport security concerns. And as a result, we see FMC, by way of this rule, specifically referencing export control and related economic embargo compliance. And that's something that everyone online should take into consideration as you move forward, be it by way of a license application or even as a renewal process if you are a current licensee. We're moving ahead now, and more or less we're on time. As I said at the beginning, we're looking at trying to reserve about 10 minutes or so for questions and answer, and I believe we're starting to get some questions as we move along here, so that's good. And I thank you, and I promise you we'll get to them as soon as we can. Before you now, another area that the FMC dealt with in its rulemaking, and that is a streamlining of the appellate process for a denial or suspension, or in the worst case, a revocation of a license. In effect, what the FMC has done here is to help introduce some practical realities in what we would describe as a very unfortunate situation, and hopefully one in which the audience will never have to contemplate. But as we sum up, the Bureau of Certification and Licensing, BCL, has the responsibility, as we all know, I think, those of us online, for the review, the consideration, the issuance of a license. And what the FMC has done here is to charge BCL with the authority to deliver to a hearing officer within the FMC a copy of the Notice of Intent. What we have before us is a summary of the new rules by way of streamlining the appellate process for a situation which we hope none of us will ever find ourselves in. And that is whether we have to deal with the denial of a license by the FMC, the suspension of an existing license, or in the worst case, the revocation of a license. What the rule does now is charge the Bureau of Certification and Licensing, BCL, with the authority to deliver to a hearing officer within the FMC a copy of the Notice of Intent and supporting materials as to why either the license application should be denied or the existing license should be suspended or revoked. At that point, the hearing officer within the FMC will approach the applicant or the licensee, provide them with the BCL position, the materials, the notice, and provide the party 30 days to prepare and respond to the BCL position. OTA applicants and licensees must submit their information, their data, in response to BCL's position. At that point, BCL does have an opportunity to provide a counterpoint within 20 days of the OTI's counter, if you will. And then at that point, we have a 40-day clock that starts ticking, by which time the hearing officer will render a decision based on the information before him or her. Now, in many ways, what we have here is not that much different than the process in the past, although it does streamline the FMC procedure, and it does set specific timetables for moving things along, which is consistent with what other federal agencies have done in the last decade or so in terms of imposing specific timelines on the agency itself for procedural issues and consideration of a final determination on an issue before it. So, as we said at the beginning of this particular provision, hopefully this is an area that no one online will have to deal with. But if you do find yourself in such a situation, then we would suggest that be aware of the specific procedures and then also the deadlines. I will say that over the last 10 to 15 years, the FMC has changed, and formal docketed matters are not quite as numerous as they used to be. And as a result, the FMC has also introduced some alternative dispute resolution protocol. There is and has been an emphasis throughout the last several chairmen for those within the industry that have grievances. Approaching the FMC may be an option. Looking to someone within the FMC's ADR branch is something that the FMC has encouraged. And so we find here is something that's in parallel to that. Specific deadlines, the FMC saying to you as the regulated or would-be regulated party, go ahead and look to us to help you. You may need counsel or you may not, but please know that there's a procedure in place.
So the FMC has always required OTIs to update the agency with regard to certain changes to the information regarding an OTI. A number of those required reportable items are items which require the FMC's approval. So that's like a change in the QI, addition of a trade name, change in the name to the entity, transfer of a license, etc. Those things have been enumerated in the rules for some time and require the filing of an FMC 18 to report them. What the FMC did here in the rules was to also enumerate, although not an exclusive list, but provide examples of the other types of material changes that are reportable to the FMC. So for example, business address changes, certain criminal indictments and convictions, bankruptcies, changes of ownership, changes in partners for partnerships, members or managers, and also changes in branch offices. So, for example, the addition of branch offices, deletion of branch offices, change of an address of a branch office. All of these are considered material changes, and I know that this is not an exhaustive list. So any other changes that are in a similar vein should also be reported to the FMC. These changes need to be reported within 30 days of the effective date of the change, and can be notified. The FMC can be notified in writing. We often will prepare a letter that goes into the FMC that advises them of the change and provides the required information. So again, in the suggestions section here, as noted, if we're talking about a change that requires commission approval, then you do need to go through the FMC application process. This is a longer process. There is a full application, or the applicable parts of the application need to be filled out, submitted to the agency. An analyst is assigned, they'll review it, and then they'll make a decision as to whether that change is approved. So for those types of changes, you should keep in mind that you do need a little bit of additional time, lead time here, to allow the agency to review those changes. For the other changes, the quote-unquote material changes that are reportable but do not require approval, as noted, those can be reported within 30 days. So even 30 days after the change, you can notify the agency in writing about the change, and then you've met your obligations.
Thanks, Liz. Moving along, we now turn to changes to some extent regarding records and books of account, i.e. record-keeping responsibilities for OTIs. And in this instance, the FMC really didn't introduce any significant change. What they did is take the opportunity to essentially remind folks that as a regulated entity, OTIs, i.e. forwarders and NBOs, are obligated to make records and books of account available to the FMC upon request. This is nothing new. In fact, everyone that holds a license, when you receive the license from the FMC, at some point you received an accompanying letter in which the FMC was kind enough to kind of walk you through and provide you with notice of certain key core areas of responsibility as a licensee. And one of those, of course, is that you have to retain responsive records for 5 years, and upon request by the Federal Maritime Commission, make them available. Again, nothing new here. The second bullet does touch upon an area that is rather commonsensical, but the FMC took the opportunity to underscore that OTIs must require their agents, be it here or overseas, here being in the United States, that they must disclose records relating to the principal OTI's activities when requested by the Federal Maritime Commission. Again, nothing that's completely earth-shattering, and arguably something that is not new. But what is the simple fact that the FMC took the opportunity by way of this rulemaking to make it clear as they could possibly make it that your agents are now obligated to provide the FMC with responsive material upon request. So, what does that mean in terms of some practical suggestions for everyone? First, we would say that you should ensure that your agents are willing and able to meet this requirement, that is, to be responsive to an FMC request. Practically speaking, of course, you should make certain that your agent is coordinating with you as the principal and that they are letting you know that a request has been received by the agency to provide information in their capacity as an agent for you, the principal. To that effect, we would suggest that any language in your agency agreement be revisited, tightened, revised, or inserted to ensure that this point is absolutely ironclad as the principle, that is. From a BCO, a shipper perspective, even though you're not directly regulated in this sense by the agency, if you do receive a request for information, data, documentation, which is not unheard of, by the FMC, You should treat that like you would any other request from a federal agency. And at this point, we would say that you should consult with counsel to make certain that you're responsive to the agency request. That has taken us through more or less on time. We have about 15 minutes left. Liz and I have kind of broken down the key aspects of the new rules, and we'd like to turn it over to Martin for some thoughts and comments from his side of the perspective. And on that point, Martin, I'll turn it to you.
Thank you, Ashley. Thank you, Liz, and Happy New Year, everybody. Thanks for attending our webinar. And I just wanted to point out a couple of things that ThreadGate and Venable provided together from a compliance side that is way broader than just FMC compliance, but we always try to enable our customers and the industry at large to best of our ability to find clever solutions to comply with the law and stay on the right side of all the agencies out there. And as such, for example, we have a ThreadGate compliance suite that is comprised of very many web service-enabled solutions that include certified plugins for ERP systems such as the leading cloud-based solution for NetSuite. We offer FMC publishing, ISF filings, denied person screenings, and more, all web services enabled, so you can integrate these compliance pieces into your operating system and business processes as you see fit. So if you have workflow engines that handle your day-to-day business, you can just make a web services call to our platform and get the results back in the appropriate fashion. And from an MBO OTI perspective, our leading rate management and quoting and sales automation solution that offers routing guides and more also offers integrated FMC publishing and code acceptance for NRA record keeping. And with that said, I wanted to point out that while many people in the industry offer solutions that charge you for every single filing, we've taken a quite different approach that hopefully will enable all our customers to not have to think about the nickel and dime approach that many others do and being charged for every single filing. We basically have a all-you-can-file philosophy embedded in our solutions and come up with packages that help our customers be compliant without having to worry about the amount of filings, and in case of doubt, just file it and be safe instead of having to turn around the dollar and then potentially be in violation of the rules and regulations. We're also planning a couple of new web services with these new regulations coming online, so hopefully there will be a way to verify if there were claims against certain of these bonds, and of course verification of the licensing requirements as published by the FMC will be available as part of the compliance suite via a web service call to our customers. There are many more solutions, so whenever it comes to compliance or automation, we do encourage everybody to just give us a jingle and see what we have in our war chest, and hopefully we can help you be better at what you do with the technology we provide on our cloud platform.
Thank you, Martin, very much for that. So for those of us that are still online, we're going to move into the Q&A session. Very briefly, I'm not going to run through, but what you have in front of you is just an overview of who we are at Venable and what we do. Simply put, we day in and day out work with members of the industry, all sectors, and I think it's fair to say that we appreciate what you do. You're very much involved in the flow of commerce from A to B, and it's something, frankly, that we look forward to doing. We know the industry, but we find it always fascinating to uncover a new issue here or there. Having said that, to be very practical, you'll see that we've embedded in this slide at the very end a reference to one of our alerts that we sent out. Now, this alert provides you with a fairly user-friendly overview in chart format of the old rules and the new rules and the key changes that have been brought about by the FMC's actions in November of last year. We also have embedded in this link a hyperlink that will take you to the actual Federal Register notice with the actual underlying new rules for your own reference. So we hope that you find that to be useful. Having said all that, we're going to turn to the Q&A, but I would be remiss if I didn't say that we have this material available, and we'll be providing it to those of you that did register with us. I know we've gotten a couple comments throughout the presentation from folks asking if they could see and have a copy of the presentation, and the answer is yes. You'll get it as soon as we can, later today or tomorrow or so. So on that note, Liz, I'll turn to you for the first question that we have here.
Sure, and please feel free to send questions in through the chat feature as we continue moving through. One question that we received is about the intersection, if any, between the Federal Motor Carrier Safety Administration, FMCSA, bond requirements and the FMC, Federal Maritime Commission bond requirements. And the answer to that is that they are two separate bond requirements, two separate agencies. If anybody online, and I know a number of the OTIs online probably also provide surface transportation. So you're probably registered as a surface freight forwarder or potentially as a property broker. The FMCSA has its own bond requirement, $75,000, but that can cover both freight forwarding activities and property broker activities. That is separate and apart from the FMC's ocean freight forwarding bond requirement, which is, as we noted earlier, $50,000.
Thanks, Liz. So next question we have refers to character and fitness requirements. And the specific question is, do character requirements apply to all employees or only to qualifying individuals, QIs, who are listed on the OTI application? Or will the staff be listed and vetted in OTI renewal request? So the character issues that we walked through earlier that Liz did, if I recall correctly, that helped to clarify the way the FMC has approached this in the past, apply twofold. First and foremost, we're talking about the company itself holding the license for the most part, although individuals, if you're acting as a sole proprietor, may hold the license in your name. But in terms of a corporate entity, we're talking about that company holding the license. But to get the license, of course, I think we all know you need a qualifying individual, which has to be an active corporate officer. The FMC will look at this individual and determine whether he or she has the requisite requirements and has the character in order to be designated as a QI. So the litany of points that Liz walked through go to the QI, the individual. Having said that, I don't think it would be unheard of if the FMC found that, say, one of the officers of the company, the CEO, who's not the proposed QI, had a series of issues, say, to keep with the theme, export compliance violations, that he or she was personally responsible for. That may be construed against the company itself holding an OTI license. And I do think that it's fair to say, as the FMC has moved closer in alignment with sister agencies such as Commerce and State, as well as Treasury, which have been on the front line for years with regards to export compliance and economic sanctions enforcement, you'll see a higher level of scrutiny from the FMC on new applications beyond just the individual QI. So to sum up, what we walked you through applies for the most part to the individual proposed QI, but we should be mindful that the FMC could factor into consideration other individuals that are of significance within the company in terms of issuing the license in the name of the company. So I think, if I may also go back to the question, I believe that there may be some concern that the FMC is going to vet every single individual associated with the company, and I don't believe that's the case. The FMC has not really done that, doesn't have necessarily the resources to do that. On average today, new licenses are taking anywhere between maybe 2 to 4 months, plus or minus, if we're lucky. The FMC does receive a lot of applications, and they do their very best to go through them in a timely manner. So I don't think you have to worry about the FMC looking from A to Z throughout the company, but do keep in mind what I just mentioned, which is the QI, most definitely, the issues that Liz walked you through, and then some of the other company officials associated with it if there are issues that maybe rise to the level of concern. I think we have another question or two.
Another one that's with regards to use of overseas agents who have contract rates with the VOCC, and whether that agent whether an OTI must verify that the agent is licensed or registered if they're requested to book cargo on their behalf. If the cargo is going to be touching the United States and it's being booked on behalf of that agent who is itself holding itself out as providing ocean transportation services, then yes, that agent should be verified that they are in good standing and authorized to perform ocean transportation services that touch the United States, so we're in the U.S. foreign commerce. Also, we would just recommend in general, again, as noted earlier, it's a good due diligence point to make sure that the agent has proper bonding in place from a practical standpoint. To the extent that the services an OTI is providing on behalf of that agent don't touch the United States, then those are outside of the jurisdiction of the FMC. I think that addresses that. And we also had a brief, not so much a substantive question, but a question about the link to the client alert. When we send the PDF copy of this to everybody, the link should be live, but we will also include a copy of the client alert with the materials that go out so everyone can be sure to have that.
Thank you, Liz. And let me thank everyone online for sitting in and listening to us. I hope you found our presentation today to be practical, insightful, and at the end, useful. That was our objective. We have somehow managed to stay right within the 60-minute mark. We're rounding down here as we speak. If anyone does have a last-minute question, by all means, do feel free to send it our way. I'll continue to talk and eat up a little bit of the clock here. Having said that, if anyone does have any questions, do feel free to email either Liz or myself. Of course, reach out to Martin as well if you have a question regarding FreightGate's capabilities, services, and offerings. But do feel free to reach out to us regarding the FMC rules. We would be more than happy to respond to you. And on that, it looks like we're good. So thank you all again for your time and consideration, and best to you all in 2016.